Great. The AI is taking over. I have to figure out how to turn that off another time. Okay. So hello, I'm Ian Stevenson from Siacombe, and I'm delighted to welcome you to our third Guardians for Good podcast. My guest today is Jim Cole, whose career includes more than 22 years at Homeland Security Investigations, combating child exploitation and pioneering victim-centric investigative methodologies, which is not as easy to say as I thought when I wrote it down. Welcome, Jim.
Thank you. Thank you for having me in.
So that's probably a good place to start, since I've already stumbled over it once. Victim-centric investigative methodologies. What do we mean by that?
Yeah, so it kind of stemmed from a very specific case that impacted my life and is really the reason that we're talking today. I started working child sexual exploitation investigations on a pure happenstance when assigned by my supervisor after I helped him format a Word document, and he turned to me and said, "Ooh, you're a technology guy." And so I thought, wow, if helping you format a Word document makes me a technology guy, well, sure. But I was always drawn by technology, earlier adopter of different technologies, in the different and various roles I was in throughout my law enforcement career, which started in the military and then into local law enforcement and then into federal law enforcement. I was always kind of that guy that was looking to utilize technology to just help us with whatever that particular mission was at the time. And so I get pulled into this role. I get taught how to, my mentor who taught me how to work those cases had been doing it in the age of magazines and, pictures you held in your hand, and then into physical tape, that had different, looks throughout, the time that we were using tape. And so, and then it kind of exploded in the online realm. And so the way that law enforcement was working these crimes then was very offender focused. It was all about, catching the bad guy. And largely law enforcement was a little bit tunnel visioned, and that meant, like, well, if you were in possession of child sexual abuse material, if you were in, or you were trading it, and I think there was an idea that the folks that were producing it were at the very kind of top of this pyramid. They're the very, very small subset, and then the pyramid gets bigger as you go down to the people who are distributing it, and then the people who possess it is the largest body. And not that that isn't true, but I think over time, the folks that were producing it, that subset grew larger and larger and larger. But there was this idea that those people were far away. It wasn't the people we were working. And so there was a focus on just getting the traders and the possessors of child sexual abuse material. And that meant that when they looked at these cases, when they were investigating the case, when they were conducting the digital forensics on the case, when they were analyzing the evidence that came from all that, the focus was about finding the files to show the crime kind of as quickly as possible, using certain techniques and methodologies that didn't really lend themselves or didn't incentivize digging into that data and looking for new victims. And so this particular investigation came along, and I don't name the investigation because the survivor in that investigation was unfortunately put out there to the general public in association with the material. And so that's affected their lives significantly. And there have been a lot of, unfortunately, there've been several occasions where her identity has been compromised. And so, but in that particular case, um, it dawned on me after speaking with the family. It dawned on me that we were kind of doing this, we weren't doing this the right way. And in this particular case, some good friends, Warren Bulmer and Bill McGarry up in the Toronto Police Service, actually had started seizing the the child sexual abuse material in this case from numerous offenders. And they knew that through international collaboration that this particular case was still, as of yet, unidentified, unsolved. And so they actually specifically set out and said, not only like, well, who is in possession of this and who's trading it, but who created it, and can we identify and rescue this child? And so they put into motion some very specific things to do that, and which surfaced some clues that led to the Portland, Oregon area. And so the case came into our office, and my partner at the time was a guy named Josh Finley. We're both retired HSI agents now. And Josh and I kind of took a look, and we worked with the Oregon ICAC. And it was the very first time we had done, I mean, a ton of child exploitation cases. It was the very first time that we were specifically looking for a child victim that we thought was in our area. And so we got really creative. We worked with the Oregon ICAC, and we got creative, and we started pulling out different things to specifically try and find that child. And when she was identified, she turns out she self-rescues. So she basically removed herself from further harm. And then eventually she would report that to her mom, which then goes to law enforcement, which ensues the investigation. And and eventually we put that puzzle piece together, although we searched for her for a year and a half after she had self-identified, because the deconfliction piece didn't happen. It inadvertently, two people, one person thought the other one was going to do it. The forensic examiner thought the investigator was going to do it. The investigator thought the forensic examiner was going to do it, which meant no one did it. And so it didn't get to the National Center for Missing and Exploited Children's Child Victim Identification Program, which is the central clearinghouse in the United States for these cases, where deconfliction would have happened. And so that led Josh and I and others, some really incredible partners, to be physically out there looking for her for a year and a half after she was already safe. And the reason that we were looking in the Portland, Oregon area, all those clues that led there, was because, in fact, the video that had most of the clues in it was actually made in the Portland, Oregon area. But it was on a trip. It's not where they lived. And so we were out there looking for her, thinking that she likely was in our area, and all along was not. And so when the piece finally gets put together, and we figure out, she's a good couple 100 miles away, she's about 250 miles away. Then we start working toward showing what happened in the Portland, Oregon area, because that's an additional and very serious criminal charge. Transporting a minor over state lines and then engaging in illicit sexual conduct is a significant federal charge. And then he fled. He ended up fleeing to a circuitous route to China, and was a federal fugitive, was on the U.S. Marshals 10 most wanted list, was on HSI's 15 most wanted list. And we put together a whole task force just to find him and recover him as a fugitive. But during that investigation, Josh and I had contact with the family. When they learned about the things that we had done to try to identify her, it really touched them in a significant way. And their reaction touched us in a significant way. And in having several hours on a drive to think about it, I started putting together, wow, we're kind of doing this wrong, because we're not trying to find that data in all the data that we're seizing. And so how do we put victims first? How do we create more of a victim-centric methodology versus an offender-centric methodology? And so I started piecing some of that together on the drive back. And then the next day that I was in the office, I pulled 3 cases out of the evidence room that were done and dusted. I mean, one of the guys was already sentenced and in federal prison, and 2 were pre-sentenced, about to be sentenced within a couple months. And I thought, gosh, if there, out of all the cases that I've got, if there's hands-on offenders, these are the 3 that they're going to be hands-on offenders. So I started developing that methodology by reprocessing those cases from a different perspective. And typically the way that we did these cases before is we use hash sets. By and large, we relied heavily on hash sets, right? And so with those hash sets, one thing that is by the very fact that a file is on the hash set means it's not new, right? And it's probably, I mean, in the scheme of things, fairly old, because it's gone through a whole process to make its way onto that list, right? That hash list. And so investigators have looked at it and said, yeah, this is a file of interest. This is something that if it were on a computer or device that we seize as part of investigation, I would want to know about. I might want to charge that file. And so it ends up on a hash list that then forensically we run the hash list as part of the forensics process. It pulls all those files into a nice spot to look at. And historically, what we did is then we focused there. We spent all of our time on those files that the hash list helped us find, in figuring out, well, what's the worst of the worst that I'm going to, out of the thousands of files that I found, and every jurisdiction is a little bit different. So, federally, we need to find, usually we want to find a significant amount more than 600 files to charge, because the federal sentencing guidelines have some thresholds, and 600 is the maximum. So if I can find 2,500 files, well, then there are going to be at least 600 in there that are no question illegal files a lot of the states, it's like 10 or 20 or 25 or even 100. So it just depends on the jurisdiction you're going to prosecute the case in. But basically what we do is we'd focus on what I call the alert files, the hits, and we pull out, well, these are the ones that I'm going to use and send over to the prosecutor to charge. I'm going to write descriptions of these files. So I'd spend time writing descriptions of the files and giving them to the prosecutor. And then, when we go to grand jury to indict, those are the files we're going to use in the grand jury. And when I testify, those are the file descriptions I'm going to read to the grand jury. And they're undoubtedly a minor that's depicted, right? Because that's one of the key components. And it's undoubtedly illegal activity based on whatever the statutory definition is of the crime. But the problem with that is, because you're spending so much time on those files, you're not looking the more difficult problem, which is the files that could be buried in there that may show that your offender is a hands-on offender, abusing a child that is within his reach to abuse. Or the other is, he may be directly connected to a hands-on offender who has provided information that's not widely distributed, but was privately distributed to him because there's a trust between the two. And either of those situations is incredibly important to figure out, because a couple of things. One, there's a real child in danger, maybe more than one. And number 2, we have the opportunity to safeguard that child quickly. And so often what was happening was, we weren't figuring out there was a real child in that mix until we sent it to NCMEC, and they came back and said, hey, this is a file that we've not seen before, or this is a file we've only seen a couple times before and it's unidentified. Or we weren't sending it, it was getting buried in the data totally, it was not being surfaced at all. And what I kind of term was like, we were shoving kids into the evidence room. So when I pulled those 3 cases out, and I did those 3 cases, I ended up finding 5 child victims that I had not previously found in 2 of the 3 cases, which meant, if you think about it, so one offender had 3 victims that I had just completely missed, and one offender had 2 victims. And in each of the cases, it was familial. It was either the the children of the offender, or it was a child relative of the offender. And that's what gave them the access to those children to offend and create the material. And so by developing the methodology, that's how Project Vic was born, in one way, and co-founded with Rich Brown. And after we got talking about this issue, and then two, it's how the HSI Victim Identification Program and Laboratory were born.
So this is really about almost going back to why law enforcement exists in the first place, right? Because
right.
it seems like the environment you were in, there was a bit of a mentality of, enforcing the laws means catching the offenders and putting them behind bars for some set of things we can find. And the methodology was effective at doing that. But actually, the whole reason we have laws in the first place is not because we want to arbitrarily catch bad guys. It's to protect the wider public, in this case, to protect children from abuse. And that piece had sort of got a little bit lost from the puzzle. The focus was on finding enough to get a good prosecution and sentence. The focus was on that piece, not on, well, hang on, what else can we find on top of that leads us to victims we didn't know about, who may be in contact with this person or maybe in contact with someone in their network.
Yeah, it's exactly right. So I think part of the problem, and we talked about this kind of a lot over the years, is when law enforcement at any stage is early and very impressionable, because you're going to the academy, you get hired and you're excited and you go to the academy, right? Well, at the academy, it's kind of like taught, like, the law enforcement is about taking bad guys off the street, and there's this premise that when you take bad people off the street, you're protecting the public, right? Because then when they're incarcerated, they can't commit more crimes against the public, right? The problem is, and that works for some crime types, okay? That's fine for certain crime types, right? The issue is, in this particular crime type, that's only a partial solution. And one of the things we found was that this idea of, like, well, we're incarcerating the bad guys, which then protects the public. Well, that was only partially true in this crime type, because what was happening is the charges of, like, receipt or distribution of CSAM, or the possession of CSAM, have much lesser sentencing, right? So these people are being removed, incarcerated for much lesser, and in some cases, in state charges, they're not being incarcerated at all. They're getting probationary sentences. If it's just possession, and I'm going to say just in quotes, right? Because I don't believe there's such a thing as just possession. Unfortunately, sometimes the judiciary and things, well, they just possess some pictures, right? But those pictures are literally the memorialization of the worst moment of a child's life. It is the rape, right, and sexual assault of a child. And so I don't believe in the term just pictures, right? But we do hear that often. And so when we're putting and I'll tell you, federally, almost always we have a receipt charge. You can, if they possessed it, logically they received it. We just have to prove how they received it, right? And so, but that was usually easy to do, and that's a 5-year prison sentence. That's what they're going to get. And so, but you think about, like, I look at the cases and the 5 victims that were pulled out of the evidence room that I had stuck in the evidence room previously, right? The youngest victim in that case was 4. And so if a 4-year-old is being abused by their father, and then we arrest that father and we put them in prison for 5 years, then there's a high likelihood that that offender will be back in that child's life. They're just going to be 5 years older.
Yeah.
And
that's still only 9 years old, which is
that's right. Still very vulnerable.
Which is a huge problem from this point of view. Yeah.
That's right. And so there's a good chance that we were not only shoving victims in the evidence room, which has a huge set of problems, because one, they're not getting the services, right? They haven't been identified as a victim, which means they're not entitled to any federally funded or state funded victim services. They're not being right. And so it leaves them in just a mire in the trauma, without any help. And then two, very likely we're putting them right back in harm's way later on, because anybody who thinks that just because a father was convicted of the offense of the possession, receipt, or distribution of child sexual abuse material, that a court will not award that father some sort of either custody or visitation, or they're going to be back in the home, right? Like it is a fallacy, because unfortunately, the kind of the courts kind of the mindset is families are better together, children need fathers, and yeah, but they serve their time, and we might put a couple of constraints on it, but we're not going to keep a father away from their child, and vice versa. And so, there's a high likelihood that that child ends up back in an abusive situation.
And by doing the extra work to go beyond the charge for possession, the charge for receipt, you can get to a point where sentencing is going way beyond what it was, which keeps them out of the child's life for longer, where courts have something that says, well, hang on, there's a contact offense here. So when they're considering family is best, they've got a pretty big red flag to say, this wasn't, I'll do your air quotes, this wasn't just pictures. That, this person was abusing this child before. Why would we put them with them again? And of course, the child gets access to the services and support they need. So it really transforms the outcome of the whole situation to take that approach.
Remarkably. And so so number one, the sentencing for the hands-on offense is order of magnitude bigger than less. So, we're putting folks away for oftentimes functional equivalent of life, right? They're never going
Yes.
to get out of prison. Other sentences, I mean, look, on the lower end, we're looking at a 15-year sentence, right? So in most cases, unless the child was an infant, that child is going to be, an adult at the time of release. But oftentimes we're seeing, routinely we were seeing sentences of 35, 45 years, and above. I had one sentence of 3,700 years in
Oh my.
Arizona. Arizona, the state charging is better than the federal charging, which is not the case in most states. But one offender who had multiple victims, and the judge, the offender was being particularly difficult, and so was sentenced to 3,700 years.
My goodness, I've never heard of such a thing, but that
Yeah.
certainly makes sure they're not going to
Right.
easily be in a position to offend again in their
That's right.
lifetime. So, I mean, I can understand that it's easy to get focused on charging the offender and finding the images on the device. I can understand that you prioritize the images that you can, identify most easily. That makes a certain amount of sense to me. Why people would take that approach. But I'm sort of going to imagine that if you as a law enforcement officer you've got a warrant, you're going into somebody's home because they're suspected of this offence, you're starting to find evidence that they clearly have a sexual interest in children and are living that out through images or whatever. If there are children in that home or their immediate vicinity, to me it seems obvious that you'd look there, but I guess that's not always happening.
Yeah, it's not always happening. I think, some of it goes down to the interview, and then some of it goes to, so certainly if there's a child at home, we will almost always take them to a forensic interview and have a forensics child interview done, right? The problem is that there's a heavy reliance on a disclosure, right?
Yeah.
So it's one of the flaws, and it's difficult. It's a difficult issue. So if we arrange the forensic child interview for a child that's within proximity of the, particularly if it's a child of the offender, and then they go into that forensic child interview and they don't disclose abuse,
Yeah.
it's kind of like, oh well,
And there
hands are
are all
tied.
sorts of reasons why that might be the case, which
Yeah, there's a ton of
don't
reasons
indicate an
that's like
absence
a
of
whole
abuse.
other thing. But yeah, there are a ton of reasons that disclosures are not common, and I've talked to numerous survivors who will, in conversation, say, I was interviewed and I didn't disclose, yet it was happening to me. And it was happening to me, but there's an issue of grooming, and manipulation of children, and there are strong psychological barriers that prevent children from disclosing, right? That offenders, plant into children, amongst just all the other reasons, right? There's a ton of reasons that the system doesn't make it easy to disclose. I'll tell you that, right? Like, and so there's a lot of issues there. But
So
yeah,
if
so
digital work can find evidence of that abuse, then suddenly you can really change how you approach
that's
that
right. The
conversation
disclosure, the
and
disclosure is not
put, put
necessary.
put pressure on that. Yeah, yeah,
That's right.
clearly makes a transformational difference. Um, the world is changing around us at an enormous pace at the moment. I've so far managed to resist creating a Studio Ghibli version of myself with the latest version of Chat GPT. But it's very hard to have a conversation about almost any subject without talking about AI, and the creation of AI imagery must muddy the waters a little for investigators in terms of what they're finding on computers, because there must be a fear that even if you find an image, it is a fabricated one, and there isn't a real victim but behind it. How does that fit in?
Yeah, it's a challenge, right? So we're certainly seeing what we're calling AI generated CSAM that is convincingly real. And then there are issues in that it is hard to know if it is wholly generated AI, right, from scratch, or if it is a hybrid type image that is generated AI using real imagery of a victim or a person or a scenario even, right? So, for instance, I'm aware that several of the different investigations that I worked, and stay in touch with the survivors of, that some of those are older series, or they're 90s era, early 2000s era, and the abuse stopped at a certain point, and the production of the material stopped at a certain point, and now offenders are using AI to carry those series on into the modern era, which is tremendously traumatic to those survivors. And then I'm also aware that we have a problem in our schools, right? We have a problem um, with teens creating imagery of their classmates and their peers, and then using that to bully and extort and all kinds of things. And in the digital age, the problem is, a teenage boy creates an image of a teenage girl in the school, and now not only does it spread throughout that school, but then it cross pollinates into the next school and the next school and the county and the next city over, and it's becomes a massive issue. And
And
so
and this is happening in apps that advertise that very often that advertise themselves as nudification, which
nudificate,
sounds
yeah,
harmless or a little bit fun or something. But what we're actually
yeah,
talking about, especially when it comes to young people, is the creation of illegal imagery
yeah,
of children.
yeah,
It's a form of sexual assault. I mean, it is with
yeah,
adults as well, but even more, it's even more relevant to this conversation. What's happening with children?
yeah. And so it's a huge problem, and we're taking a look at, how are we going to address this issue, and how do we detect when imagery is AI generated, and then if it's a hybrid, can we detect where the manipulation is, and all these different things, like there's not just the Nudify apps are one, but there's a lot of face swap apps. So you can start with a face swap app, and then you can move that over into a generative AI tool, and so it's not always just one tool, and so that creates issues for the detectors as well. So it's a complicated issue. And then the other issue is, our legal framework just isn't caught up, right, to these issues. We're using age-old statutes to charge AI-generated material in the United States right now. Federally, we use an obscenity statute versus the child sexual abuse material statute. The issue is, like, recently in one particular district, a federal court judge tossed a couple of the charges out, saying that it was protected by the First Amendment and the Constitution or free speech because it didn't depict a real child. That is in line with a Supreme Court decision that happened in 1999, called Ashcroft v. Free Speech Coalition, where the Supreme Court ruled that a segment of the federal statute was unconstitutional, in that it basically said that anything that was like the likeness of a child that met the definition of what the statute calls child pornography would be illegal, and the Supreme Court ruled that that would be free speech if no real child is harmed. And again, 1999 to today, it's a very different world, and we know that I think there are still harms that are caused by that type of material, and it really, now that's got to work its way through the legal system to see how that fleshes out. So we just don't know. Right now, it only affects one district, but as it works its way up through the appellate court, potentially the Supreme Court, it could affect law across the land. So we'll see. We'll see how that all turns out. I don't know. I mean, I wish I had a great answer, right? Because it's all so new, and it's all developing so incredibly fast. The ability,
but from an investigator's point of view, even if you suspect an image is AI generated, it could be AI generated and completely synthetic from top to bottom, and there isn't a real victim behind it. It could be that it's one of these hybrids you were describing, which is has used sort of face swapping technology, deep fake technology, to take a real child into that context. It could be that it's a generated image, but actually, because the generator was trained on real people, it's produced an image that is identifiable of a real person, even though that wasn't necessarily the intent of the creator. So it's a hugely complex set of different opportunities there.
Yep, it absolutely is, and it's only going to get more complicated, right? It's only going to get more complicated,
and the law will need to catch up with that.
That's
because right. I'm a huge proponent of things like privacy and free speech, but in most societies around the world, those things have boundaries. Those have been set according to the norms and the challenges that were faced at a particular point in time. And I think if you go back 20 years ago, anything synthetically created was essentially a piece of art that had been manually and painstakingly created. And perhaps there's an argument that says, well, art should be allowed to depict things that happen in the real world, even if we don't find them palatable. But the industrialization of this process with AI may well change the way that people think about that, and maybe this will prove to be a test case for it, or maybe we'll have to wait a little bit longer.
I hope so.
So look, that's been a fantastic conversation. I guess the messages I'd take out of that I think our community, the people in the digital forensics world, are going to benefit from are all around the importance of making sure that everything is done to identify victims, that victims who are identified are communicated to NECMEC so that process can run efficiently, or even if they're not identified, that the materials communicated to NECMEC so that you don't end up with duplicated investigations. And that by doing so, not only do we rescue children, but we actually also see far, far greater sentences being applied to those who are causing harm that are in line with their real offences, rather than perhaps the first thing we see. So that's, I think, a great set of messages to take away. So thank you very much indeed for your time today, Jim. It's been an absolute pleasure, but that's all we have time for just now.
Thanks, Ian. I appreciate the time.